Okay, great. Let's get started, everyone. Welcome back after your break. I hope you had a good time away from classes at least, although I understand it probably wasn't time away from contract law. And I hope that you all managed to get your assignments in on time this morning. And that's another one milestone off. And now that we've got that out of the way, we can concentrate on your exams, which are coming up quicker than probably you would like. What I thought we'd do today is going to go through some exam prep and tips, etc., that will hopefully help you with your study for the exam in a few weeks. And then we will go through a question together on frustration, which will also have the added benefit of getting you back into the swing of frustration, because I understand, of course, I realise we did it a few weeks ago. And then we will use that to springboard into the rest of frustration, which is going to be looking at consequences of a finding that a contract has been frustrated. So, before we do that, just to, we mentioned it earlier, but I'll be looking at frustration this week. Josh will come back and finish Miss Rep with you next week, and then you'll have me for the rest of the semester. We've just swapped that week because Josh was away in Singapore and it's school holidays next week, so that helps if I'm not teaching. So that's the plan. So you'll have me this week, Josh next week, and then me for the rest of the semester. We're going to finish frustration this week. You'll do misrep next week with Josh, and then you'll have me, and we will look at mistake and then terms, and that will take up the last 4 weeks of the semester. Cool? Before we start any of that, let's talk about your exam. So the reason why we've put out this announcement, and the reason why I'm talking about this now, is that you should probably start thinking about and preparing yourself for the exams now. Particularly contract law. I don't care about the other ones, but particularly contract law, you should be preparing yourself for that, and because it will be upon you before you know it. So if you haven't figured out the exam time and date, I suggest you go do that at the on the relevant website. This year's contract law exam is going to be in Mode D, which you will probably be familiar with. This is the mode that all the CLE mandated courses such as contract law are in. That is the mode whereby you come into the university, you're invigilated, and you are writing the exam on your own laptop. You are writing, though, onto the Inspira Integrity browser on your laptop, which means the only thing you'll be able to do online is write your exam. There'll be no ability to go outside that and look at other material. However, it is an open book exam, which means you are free to bring in any material you wish as long as it's hard copy. Okay, so it's another reason to start now, is to start getting your notes in order so you can bring them in with you to the exam. Okay, so you're in person, you're typing on your laptop, and you can take any material you want in, but it has to be hard copy. You will not be able to search your notes online, or indeed anything else. Yes, Lucy?
How much hard copy would it actually, how many pages?
As much as you want. Reams, libraries, anything you want. It probably has to physically fit through the door and onto your desk, but apart from that, whatever you'd like. Having said all that, I would not recommend relying on your notes during the exam, and that if you are trying to figure out what the law on frustration is during the exam, you're not going to be using your time particularly well. You really need to have a firm grasp of the law and the how to apply the law and the various permutations of it before you get into the exam itself. I would use the notes and your material as a security blanket, just to there if you really have a mind blank, it's there. But if you're having to search through notes to figure out, oh, I wonder what the ratio of Planet Kids is, you're going to be wasting your time, okay? You won't have a time to really do that and do a good job in your exam. I'm going to look at a bit more after this. I'll talk about some exam tips that will expand on that, but you are free to bring anything in, but I wouldn't rely on it, okay? Please download the Integrity browser software now, okay? And then try it. Because if you leave it to the last minute, you will invariably have technical issues which will increase your stress immensely. Do it now, and then any issues you can figure out well in advance. Please do not come to me or Josh or any of the teaching team with technical issues. We don't know. Whatever your question is, we don't know. Okay, I'm sorry. But there will be people at the exams office or the technical support people that can help you at the university. But again, that's a good reason to get it done now so they can help you in good time rather than the morning of your exam. The exam itself is You will do best in the exam if you are able to quickly identify issues and quickly start identifying the relevant law and then applying the law to the facts. Okay, so a thorough knowledge of the law that we have studied is really going to mean that you do well in the exam. Again, it's not that it's it's not that it's too much, but the point is that there's a fair amount to get through in your 2.5 hours, and that you're going to do best if you are confident and competent with the law already, so you don't have to think about it during the exam. So again, that's tying back to the idea that you shouldn't be going through your notes. To help you with that, and again I'll go through it in a second, make sure you are familiar with the exams database on the University of Auckland library website. I'm sure you all are, but if not, I'll just refresh your memories. Let's go to the library website, and instead of searching for books, articles, you can just go down to exams. Okay? Make sure that you're signed in, otherwise it won't work. And then just type Law 241 for contract, and it'll come up with the last half dozen or so exams that you can then use to study. Okay, so again, get used to those, and I would recommend that you practice exams and practice doing those exams in the way that you would do the exam on the day itself. Practice as you would do it in the exam itself, and that would be the best use for you. Yeah.
Would the past exam papers be similar to the exam we're taking this year?
Good question. How similar are they? They are similar in that they are, well, we'll see, all the questions this year are problem questions. So the problem questions from previous years will be most useful. Obviously, essay questions will be less useful, aside from helping you to get a handle over the law itself. Generally, the content should be similar, but do be aware that obviously different lecturers have different emphases. But no, they should be helpful, particularly the problem questions. No exam is exactly the same in terms of the formatting and in terms of the time. This exam is no different. It's a 2.5 hour exam in which you have 3 questions. Question 1, though, is divided into 2 parts and altogether is worth 60%. Question 2 is worth 20%. Question 3 is also worth 20%, and hopefully that should add up to 100%. It does, that's good. 60 plus 20 plus 20, yep, all good. What that means, though, is that you should be allocating your time relative to how much each question is worth. There is a temptation to just spend a couple of extra minutes on each question finishing off your answer. If you can at all, resist that temptation. Stick to the timing you've set for yourself prior to the exam and start the next question. Generally, you will get more bang for your buck spending those 2 minutes starting a new question than finalising a question you've already substantially completed. Okay? And then if you have time at the end, you can come back and finish that question. But try and keep to the time that you've set yourself and be disciplined and just start again, because there's nothing worse than finishing 2 really good answers and not having any real time to get stuck in onto the third. If you could plot a graph of time versus marks awarded, you get all your marks pretty much in the first part of your answer when you're identifying issues, setting that you know the law, and then starting to analyse it than you do for completing a really good conclusion. Okay, so please do stick to your timing as much as possible. 2 questions will be drawn from semester 2 material. 1 question will be drawn from semester 1 material. I was asked this morning, are there going to be questions that combine the 2? No, they won't be. aside from the fact that semester 2 material necessarily builds on semester 1 material because we're assuming there's a valid contract, etc., etc., which requires formation, which requires those elements in semester 1. But we're not trying to trick you with this. 1 question will be from semester 1, 2 will be from the stuff you've studied this semester. But what you should also take from that is that everything's up for grabs. Okay? We're not saying that you don't have to study this or that. You have to study it all because that's how you learn it and that's how you become good lawyers. And you do get a good mark as well. We're all going to make an announcement in due course about our availability throughout the rest of the semester and also into the study break. So we won't all be similar in terms of who's got time to have questions. But I, for example, have my office hours. I'll be available for questions, and then I'll set out when I'm going to be available in that first week of study break. Okay? But look out for announcements from Josh and Ari and from Marta as well. Okay? Yes, Lucy.
What did it mean when you said that everything's up for grabs?
All the material, there's no topics that are not potentially examinable. Everything is potentially examinable. Cool. Are there any other questions about this at all? Any at all? This is the time to ask them because we're not going to go through and provide more information on the exam itself apart from this. So if there's any clarification at all, now is the time to ask.
Sorry.
Yes, Lucy.
What is the fail rate for this course?
What is the fail rate? That depends on you guys. There isn't a fail rate, it's just how good you guys are. Let's try to keep it down.
It's the 60 missing question that is supposed to be passed.
Good question. Someone asked in the first class about that. No, just that they add up to 60. Yes?
You still have the regular office hour, your regular office hour on Friday?
Yes. What did I say? It was midday till 2, I think. Is that right? Yeah, I do. Good question.
You said problem question, so you know theories like criminal justice and economic efficiency. Are we not expected then to know those? Because technically it's not really, it was a theoretical.
I would not make those assumptions. They might be relevant. But you know what I mean by a problem question. It's usually going to be an advise X or describe the likelihood of success of Y or something like that. So theories of justice or of contract law may well be relevant for determining those finely balanced questions. Cool. Any other questions at all? Cool. Okay. I want to move from these sort of practical admin-y exam questions to just go through a few tips around answering exam questions and preparing for exams. These are tips based on my own experience, and obviously I don't learn the same as everyone in this room, so what may be good for me may not work well for you, but I do think there are some general points in there that might be helpful. The first thing I'd say is that one of the reasons people tend to do better over their time in law school is because they have practiced exams, i.e. they've done a few law exams by the time they're getting into their last semesters. Practicing exams is an excellent, and indeed I'd say the best way to prepare for your exam. And what do I mean by that? I mean taking a previous exam question, figuring out how much time you would devote to that exam question in the exam itself, and then sitting down and writing the exam question under those exam conditions. Giving yourself time to just figure out, okay, how much can I actually write in 45 minutes, say, or in 36 minutes? And that includes reading the question, figuring out the issues, perhaps mapping out a very brief summary of your argument, and then writing the answer itself. And the more you can practice that, the more you will be well versed in how to do it in the exam itself, but also it's an excellent way for exposing the areas of the law that you thought you knew but actually don't when it comes to applying it. Okay, so I really recommend trying to spend time practicing exams. If you really don't have the time to write out whole answers, at least give yourself 10 minutes to read a question cold and then prep an answer. Okay? That's better than nothing. When you are doing this, I'd also recommend having your notes in order so that you can use them the same way you would in the exam itself. What I did, a good way to study and then I thought was an excellent way to take notes into the exam itself, was for each topic, say frustration, I would try and reduce that topic to one page. What frustration is, what the leading cases are, the factors that may be relevant to a finding of frustration, and what the consequences of frustration would be. And if you could get it down to a page, that does two things. Firstly, you have to understand it well if you are going to summarize it in such a manner. Secondly, you then have an excellent cheat sheet that you can take into your exam as an aid memoir as you're doing the exam itself. Okay, this question's a question on frustration. Let's pull up my sheet on frustration. Oh, yep, that's right. Okay, let's go. And it can also be a good way to have almost a pre-written summary of the law. So when you are answering a question, say on frustration, you can just say, look, frustration is a defense against a claim for breach of contract that blah, 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 blah. Okay? Now, I used to take those cheat sheets in with me to exams. I then took all my other notes as well, including my casebook and everything with me because I wanted to have the security blanket with me. But again, you shouldn't be relying on all those notes if possible. You're just not going to have the time to be able to read through those notes or read through the cases and then write a good answer. Okay, I've talked about time management. Keep to the time. When you're writing exam questions, as far as possible and as far as it's helpful, if you can, use headings to make it easy for your reader to follow you along, but it also means that you're more likely to have a grasp on the law and what structure you require. You're more likely to have a logical flow to your argument if you're using headings as well. So even something like issue, the issue in this question is whether or not the contract is frustrated. Law, frustration is a defense against a breach of contract claim, blah, 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 blah. Leading case is this. And then application, okay, these are the ways in which frustration would be argued here. And then conclusion. I would not, and again, this is very tempting, and I'm sure most of you will do it for at least the first question that you answer in the exam. Please don't ease yourself into the exam by giving a lengthy exposition about contract law and why it's a necessary way to ensure that people in a low trust environment can rely on the word of others, etc., etc., etc. Like, no one cares. I just want to know the answer to the question in front of us. You don't have time to provide a flowery introduction. You're not going to get any marks for it. Unless I ask you an essay, which I'm not because it's a problem question, around why we have contract law. So just get into it and just say, the question in this case is, or the issue here is, or I've been asked to advise you, my advice will rely on two issues, frustration and misrep, because they are the most, relevant. Or these facts raise two issues, frustration and misrep. And then just go straight into it. Okay? You don't have time to pretty your answer up with that. And then when you identify the law, make statements about the law. For example, frustration is a doctrine that applies when, as a matter of justice, the courts decide that performance under the new circumstances would be radically different from that contemplated by the party, or something like that. Brackets, Davis contractors. That's the case that you're relying on. That's the supporting that you need for that statement of law. Generally, do not quote from cases. It's almost invariably not helpful and just a waste of time. Sometimes, a paragraph or a sentence, a line or a sentence might be relevant and useful, but generally it's better just to give a broad overview of the law and then give you the case that relies on. As I said earlier, the exam is going to require you to identify issues quickly, know what the law is quickly, and then apply that law to the facts. And it's that application that's really going to set the good students from the very good students. That's the applications where those marks are really going to be, a lot of marks will be granted. The identification of the correct law is, of course, necessary, but it's not sufficient. It's that analysis part that's really going to get you a lot of good marks, okay? So, again, you won't have time to really fluff around trying to figure out what this case is about or what the issues are here. It should be fairly obvious to you. The way it becomes obvious to you is a very good understanding of the law, how the law fits together, but also practicing those exams. That will help you identify the issues quickly. When you get an exam question, a problem question, I would start, not at the start of it, I would go right to the end and I would read the question, which is usually bolded, first. What is this problem asking me to do? Make sure whatever it's asking you to do, that you then do it. Okay? Answer the question. And it sounds obvious, but lots of people don't do it. So figure out what am I being asked to do in this question, and then make sure that your answer does exactly that. So figure out, okay, I'm being asked to advise this party. So I'm advising my client, who's this person. What does this person want? Okay, what's the best way to argue for this person? But remember, advising the client doesn't mean lying to them. So if you think the client has a bad case, say so. Because the advice might be you don't have a good case, you shouldn't sue, or you should settle, or something like that. If it's to analyse the facts, then analyse the facts. If it's to, if it's more specific, would this defence have a good chance of success? Make sure you answer that. And when I say answer it, I also mean come to a firm conclusion. The arguments might be finely balanced on both sides. There will be arguments on both sides. It won't be a slam dunk argument one way or the other. But just because there are arguments on both sides doesn't mean you shouldn't come to a conclusion on one side or the other. Okay? You, of course, can say, this is a very finely balanced, there are good arguments on both sides, but then come to a conclusion. Again, clients will hate it if they pay lots and lots of money to you as a lawyer and you come back and you say, well, on the one hand this, but on the other that. No, I want your advice. Taking into account the fact that there are arguments on both sides, which one do you think more likely to succeed? And so conclude and say, there are good arguments on both sides. However, on balance, I think that the defence of frustration would be successful for this reason, or something like that. Okay, so do make sure you come to a conclusion. Don't just sit on the fence, and do make sure that you answer the question. Make sure you start the question at the time you've allocated. Don't be tempted to continue finishing it perfectly. Come back to it at the end if you need to. Get straight into it, no introductions or no flowery introductions, please. And remember that the analysis is where the majority of the marks are going to be awarded. Yeah, Lucy.
With headings like issue, relevant, or application conclusion, would they make the marker happy?
Yes, generally, headings as simple as issue, law, application, conclusion would make the marker happy. That's absolutely fine. If you want to do something a bit more complicated than that, that's also fine. There might be more than one issue, etc. But yes, something like that would be absolutely fine. You want to make it as simple as possible for the reader/marker to follow you, because what makes the marker happy generally redounds to your benefit. Any other questions at all? I know this is all what you wanted to hear as soon as you come back from break. It's all about the exam, but...
Did you say yes, make cheat sheets?
Absolutely make cheat sheets. What I mean by cheat sheets, I just mean one-page summaries. Yeah, absolutely. Really good way to study, and then I think a very good way to answer questions in the exam. Any other questions at all? If you do have questions as you're going with your study, of course I'll be available for questions as we go, but I thought it was a good time to start preparing you for the exam now, because it'll be upon us very soon. You all know the date of the exam, 11th of November, Armistice Day. It's an easy one to remember. Cool. Okay, well, with that in mind, let's go over an old exam question. But before we do, I want you to pair up with someone or get into a group of three. Find someone near to you. Make sure you're talking to someone. And I want you to discuss with them everything you can remember about frustration. What is frustration? What's the main propositions of law associated with it? Perhaps some cases you remember. And then discuss those with the person next to you, and we'll come back and share them together in about 3 or 4 minutes. So move if you have to find someone to sit beside. Make sure you're discussing with someone. We'll come back in 5 minutes. So make sure we go. Sam? Lucy? Hi.
expressing frustration.
Give you another couple of minutes. And then we'll come back and share. Okay, one more minute. Okay. Does anyone want to start us off? What is frustration, or anything about frustration you remember? I know it was a few weeks ago, so we're trying to get the memory jogged and going. Yes, thank you, sir.
It's when a contract cannot be enforced due to external events, external events beyond either party's control.
Fantastic. Okay, great. So it's a contract can't be enforced because there are external events outside either party's control. Fantastic. Great. Who wants to add to that? It's a good start. Yes, sir, at the back.
The original common law position was that if something happens, then it's tough to sign up these obligations, but then personal services piece is this implied term period to extend it to objects.
Yes, fantastic. So originally the common law said too bad, external events, or no, you have to perform what you agreed to. And then over time you started to have this broken down through the personal services cases where people died or otherwise incapacitated, and the court said, oh, well, actually in those cases you don't have to perform. And then to the destruction of particular things. And you quite rightly said the courts justified this on the idea that there was an implied term in the contract releasing the parties from their obligations when that event occurred. Excellent. Great. More to add. Yes, Lucy, and then we'll come to you.
You said that frustration is also something you can't predict based on what humans can control. So,
Ye-
for example, if you're swimming with the sharks, then the sharks might bite you. So you can...
Right, so it's foreseeable. Yes, that's fantastic. So the foreseeability or otherwise of the event in question is highly relevant to whether or not frustration would be found or not. The more foreseeable of an event, the less likely it is that the courts will hold that the contract is frustrated when the event occurs. Excellent. Yes, sorry mate, you had your hand up before? Yep. Yeah.
So I was about to say that although it's not fiction, it doesn't rely on fiction because frustration could be used as a defence.
Yes.
Right, from non-performance.
Great.
The courts would look at what is fair and just.
Yes.
See that if performance can be carried out. It's like frustration would be seen.
Great. Okay, so what was the fiction that you said? You said it won't be a fiction. What was it that the courts decided was actually a fiction? Do you remember?
Oh, the implied term theory.
Fantastic. So we've already heard the implied term theory was how the courts started to justify frustration, but then in the 20th century the court said, no, that's a fiction. We can't actually say the parties impliedly agreed anything. Instead, we are bringing the contract to an end because it will be fair and just to do so. Excellent. What was the other thing you said? Sorry, I can't remember what else you said. Was there something?
They'll look at what exactly happened.
Excellent. Okay, so what's really important, you're right, is what the parties agreed to, and then what actually happened, and now under these new circumstances, can the parties perform under these new circumstances? Great. What else do we know about frustration? This is all good. There's more. We'll come back to it, Lucy, just a sec. We'll want to hear more about what else frustration is. Yes?
In New Zealand, the leading place is Planet Kids. And
Yep.
This place talks about how we use a multifactorial test in determining whether a contract has been frustrated.
Fantastic. So the leading case in New Zealand is the Supreme Court decision of Planet Kids, which relies or brings on this multifactorial approach from the English Court of Appeal decision of the Sea Angel, Lord Justice Rex. Excellent. And what is the multifactorial approach trying to help us determine? I mean, whether it's frustrated, but more particularly, what is it trying to help us to figure out? Yeah?
Is it whether performance is radically different?
Great. Whether performance under these new circumstances is now or would be radically different than contemplated by the parties at the time they entered into the contract. In which case stands for that proposition? Where does that come from? Radically different. Where does that come from? Planet Kids talks about it, but it's citing an earlier English Davis contractors. So if I was answering a question about frustration, and I said, you know, this question is, or these facts raise the potential defence of frustration. Frustration is successful when the courts hold that performance would be radically different under the new circumstances, and then I put brackets and I'd say Davis contractors. The leading New Zealand case is Planet Kids, which set out a multifactorial approach which lists these factors which can help us determine if performance is radically different. Remember we talked about under the Planet Kids, the multifactorial approach is not a test. It's merely a way to try and help us analyse a fact scenario to figure out whether performance would be radically different, and therefore it would be just to release the parties from the burden, from the obligations. Cool. Anything else? Yeah, Lucy, question.
You know how it can be because can I please ask why it is, like what's the rationale of what the more human being can perceive for these like
Yep. Good question. Why is foreseeability relevant to this? Foreseeability is one of the factors, or the contemplation of the parties when they entered into the contract is relevant for determining if frustration is to be found. Why is that? It's a good question. Why? Yeah.
I'm not sure, but is it because it's an objective view to see what a reasonable person would foresee in the shoes of either parties, whether that external event can be foreseen?
Yes, but why is it relevant whether the event can be foreseen in advance? You're right.
Because if it could foresee, they didn't change the circumstances radically different.
Right. It's not performance now under these new circumstances wouldn't be radically different from what the parties contemplated, because when they entered into the contract, they either actually foresaw it, or as you say, a reasonable person would have foreseen it. It's foreseeable. And if you enter into the contract knowing that there's this risk, but you enter into it anyway, then performance is not radically different from what you conceived. Yeah. Yeah.
There's another reason that you could have contracted out that risk if it was foreseeable.
Yes, and you chose not to. You could have chosen not to contract. You could have chosen to up the price. You could have chosen to write a force majeure clause excusing performance in those situations, and yet you didn't.
So
Yes.
that means that if it happens, then you can't claim frustration.
Yes, that's right. So if it's foreseeable and it occurs, you can't say performance is now radically different. Yeah, that's it. Is it easy to claim frustration? No, it is a high threshold. Why is that? Because the courts want to hold people to their bargains as far as possible. So it's not easy to claim. It can't be because of either party's fault. And I think that was pretty much all I wanted to talk about. Oh, yes. One way that we looked at how the courts analyse this is, and it ties into the argument about foreseeability, is who should bear the risk that when this event occurs? Is this something that the parties have contemplated and priced in, therefore, into their contract? Is the risk of this event occurring actually one that they had allocated under the contract itself? And so we saw in that case of Salam Air, where the hirer of planes was unable to argue that COVID travel restrictions frustrated the contract. One of the reasons why was that this was a long-term bare lease of the aircraft, which effectively placed the risk of anything happening to the aircraft onto the hirer, including that the planes would not be able to be used because of a change in the law. So radically different. Generally, that's because performance is physically impossible, but not always. It could also be because performance is illegal, and it might also be because there's been a delay, like Jackson Union Marine, and finally it might be because the foundation of the contract, the reason the parties entered into this contract, has disappeared, even though performance is still physically possible. And that was the Krell and Henry, the coronation case. Okay. Any questions at all about that? Because we'll have a break now for 5 minutes if there aren't, and come back and use that information to answer an exam question from last year. But any questions at all? Okay, great. 5 minutes break. We'll come back at 5:02 and talk about the next year's exam. We'll have another 5-minute break later on as well. Cool. 5 minutes, guys. Go to the bathroom if you need, or 2.5 hours is 150 times 3 is 45 minutes. Is that right? Yeah, 75 for 50. Yeah, I think it's right.
With the whole, what you just said, you said risk allocation or something, right? So that was Salim Air where the COVID hit and all that, and all the risk was placed on the right? So what does that happen with?
So there the court said you entered into this contract under which you effectively, they gave you no matter what. So the risk of and so you can't this is not, it wouldn't be just to hold something straight, because this is exactly the kind of thing the side of the contract would be for.
Yeah, so even though whatever you said something like whatever happens with the plane, like performance can still go.
Well, yes, so it's not impossible because they can still hire the players. They just can't use it for reasonable. It's not in the risk of that is this holding like that. So it's plain and
Yeah, so if I'm talking, if that comes in like an exam and stuff, what I then mean in that case is saying the risk of party shows were allocated and therefore the courts will want to hold it to their parents.
like insurance.
Thank you.
No problem. Right, everyone, can you turn on my thing? Is there any point in putting it up there? Can you read that at all, or is that too small? I'm trying to get it so we can read everything all at once. It's the question 3 from last year's exam, which is on the database, which I asked you to have a look at before class. which is 30 marks, which means you would be spending 45 minutes on this question. So it's 45 minutes to read it, to identify the issues, and then to formulate an answer. I was a bit mean when I wrote this because I wrote too many facts. It was probably a bit long for you guys to read. Let's start off with the question. You're being asked to advise Party A, Albury, whether the other party has breached the contract they have, the fuel supply contract. So keep that in mind. You're being asked to advise Albury whether the other party has breached. And if you read further up in that last paragraph, you get a bit more of a detail about their respective arguments. It doesn't tell you anything about frustration, but if you read this last paragraph, you've got the other party responding, Maturin, that it's not responsible for the breach because the pipe was damaged not through any party's fault, and that the contract's at an end due to this intervening event. There's some fairly heavy hints there that you're being asked to discuss frustration, okay, even though it's not mentioned in the actual answer itself. Okay, I want to give you, if you've got them online, have a read online or on the board here, but I want to give you a moment, say 3 or 4 minutes to read this, and then I want to discuss together how we would go about answering this and what some of the issues might be. So what we're going to do together is one of the ways in which you can study by identifying issues and potential facts that are relevant in a short amount of time with previous exam questions. Okay, so give you 5 minutes to read that and think about it, which is probably no more than you would have in the exam. Yes? It is last year's, question 3 from last year. Yeah, sorry, if you need to get it on your computer, that's a good idea as well, because I can see that this is not actually readily readable. Oh, whoa. Well, that's much better. Yeah, well done. Have a think about the arguments that you would raise when you're advising Albury. Okay. Remember, the one question you're being asked is whether Maturin has breached the contract. You're not being asked to assess damages. You are not being asked to assess remedies in the event that a contract has been frustrated or anything. There is just one simple question: has Maturin breached the contract? You're advising Aubrey. Aubrey wants this contract to be on foot and to be broken so that he can sue the other party for breach of contract. The other party, Maturin, has said it can't be a breach of contract because of these intervening events, effectively because this has been frustrated. Okay. So how I would start this is I would figure out what is it, what term or what obligation under the contract has Maturin breached, or potentially has Maturin breached, assuming there's a contract to be breached. What is the obligation that he has failed to perform? Yes, thank you.
Supplying aviation fuel via pipeline to Aubrey for a period of 7 years.
Excellent. Under clause 3,
And then under clause 40, they have to ensure that the aviation fuel tanks will be at 90% capacity each day of the contract.
excellent. So for 7 years, every day the aviation fuel tanks need to be at 90%. What has happened to prevent Maturin fulfilling that obligation? What's happened? Yeah.
Terribly damaging rainfall.
Okay, which has what? Done what? Yes? Yeah, but what's it done?
Restricted the access to the road
Yep.
and blocked the slabs.
And blocked with slips, yep. And also what's it done to the pipe?
It's damaged it.
Great. So the pipe and the access way to the airport have been cut off for how long?
6 months.
6 months, okay? So you've got a 6-month period in which, due to weather, the pipe and roads have been damaged, which means that Maturin cannot perform its obligation by supplying the required fuel each day. So the question is, well, what is the question? This issue, or this question is all about frustration. How would you start? What would you say the question is? The basic issue or the basic question you'd have to answer if you're talking about frustration is whether or not performance under the new circumstances is radically different from what the parties contemplated when they entered into the contract. Davis contractors. Does anyone want to give me some potential arguments for or against?
I think that Aubrey was quite clearly, it seems, paying for what looked like an insurance policy. Obviously, they wanted them to ensure that against the risk they wouldn't get oil. And one of the ways you can see that is clause 8, the weekly median price plus 6.5%. That 6.5% to me at least seems to be quite obviously Aubrey paying for that assurance that it will always have as much fuel as it needs.
Okay.
I think it was quite clearly the contemplation that Maturin, at the end of the day, it's really overwhelming obligation to always ensure they have enough fuel.
Fantastic. Okay, so what is it about this clause that says to you that Aubrey's paying for the risk, or paying to ensure the risk?
It was the byproduct of additional negotiation. Aubrey was saying they really needed this, and
yes.
That's when it comes into play. And also because they're paying more than you would pay at market price, right? And
yep.
why would they be paying more than market price? It's probably because they want something extra.
Great. Okay, that's a good... So your argument is that the risk of something happening to the pipeline is one that Maturin took on under the contract, And one of the ways you can tell that is because the price they finally agreed to was much less, it was less than what Aubrey originally asked for. Great, okay. I think that's a good argument. And that the reason you would argue for this increased price is because Maturin wanted to be paid for having to take on this obligation to supply, yes, every day, and to guarantee it. Yep, great.
You could also argue that Maturin knowingly assumed a risk because they were concerned about their exposure. Last point closed down.
Great, okay, that's a good argument, but we're not quite there yet. We have to link it because Marsden Point didn't close down, did it? But I think this is relevant. Why is that relevant, though? What does it suggest about Maturin's concerns?
Well, if Marsden Point had closed down, they were concerned about that.
Yep.
Pre-execution, then performance wouldn't have radically changed if they had contemplated it.
But we have to link that somehow to the pipeline being damaged. And I think the way you do that, as some people did, is to say they knew that this was an onerous obligation on them to provide this oil when there were things outside their control in the supply chain which could be affected. In this case, it wasn't the risk to the supply chain that they were thinking about. It was another risk that actually eventuated. But it shows that they knew that this was an obligation that was quite onerous on them, and therefore they wanted to be paid for it. Yeah, so that's that they were concerned there would be disruptions to the supply chain, I think is probably how you'd frame it. Yeah, great. So therefore this is something that they assumed the risk of. Great, yep. Added to that, how long is the contract for? How many years? 7, fantastic. Again, that's not what Aubrey wanted originally. Aubrey wanted 10 years, and Maturin wanted as short as possible. And so in the end, they compromised and went with 7, which is a long time, particularly when you're concerned about supply chain disruptions, which again suggests that this was a risk that Maturin, or something like this was a risk that Maturin knew could occur, wanted to be paid for it, and was paid for it. The 7-year time frame is also relevant, I think, or is potentially relevant in another way, in that you could argue that the disruption to the pipeline was not severe enough when considering the contract as a whole. It's only for 6 months out of 7 years, which is what, 1/14? That's less than 10%, 7% of the contract time. And you could make an analogy with the argument put forward in Salam Air. Remember where the court talked about, well, it's only been a few months and this is a 5-year lease agreement. This is not such a disruption to the supply that it would be frustrated. Now, these are arguments for why it's not frustrated. Are there any arguments for why? What's Maturin going to say? What are Maturin's best arguments?
As in arguments for frustration?
Yes, for frustration, yeah.
I can think of a
Yeah.
bit of accounts.
No.
So, for example, if someone really funky gets elected as president in the US and they do something to the Middle East, and so then that's like a war.
Yes. That could be frustration, but how could they argue that what actually happened was frustration? What would be the argument you'd make on these facts? Yeah.
You say that with the insurance was a 6.5% wasn't about the fact that it could shut down. It wasn't an insurance clause, it was the fact that they were concerned that it wouldn't be worth supplying the gas.
Yep.
Because they were the only person there and the state there.
Yep.
And so they weren't actually paying for an insurance clause, they were paying because they were the sole
Yep.
operator.
Excellent. Okay, great. So the other side's placing far too much emphasis on the 6.5%. That was just us trying to get the best price possible because we've got one buyer here. What's the point of laying this pipeline otherwise? Sort of thing. Yeah, absolutely. Yeah, Lucy. Depends the impact it would have on the contract, but it's an outside event which often has large-scale consequences. The question is, has it made performance of this contract radically different? So that's why you need to be careful when you're talking about frustration. Just because, so for example, in this case, we have a once in 100-year weather event, just because it's such a serious event, doesn't necessarily mean that the contract is frustrated. You need to look at what impact that event, no matter how serious it was, has on these obligations. So, yeah, so sorry. Yeah.
Performances based become very, very difficult for maturing.
Yep.
There's an argument like how were they supposed to get oil to them? I think it's effectively impossible unless they can somehow send a team of repair people to this remote part of the country.
Yep.
Like it is just objectively a pretty big difference from what you would have in mind for the oil supplier.
Yes, or even that, we were concerned about supply chains, but that was supply chains that we'd foreseen, like Marsden Point being shut down because there's been all this talk about Marsden Point being shut down. We didn't realise that there could be this risk to the pipelines from this severe weather event. No one could have foreseen it raining in New Zealand, etc., etc. No, but you're saying that this is a really big event. We didn't foresee this. We didn't think that this would impact upon our obligations, or we didn't think about this impacting in such a manner that we can't even get there to repair it for 6 months. I mean, that's a long time to not be able to repair. That suggests extensive damage. Yeah, Lucy.
Perhaps you can claim frustration because I think people during Cyclone Gabrielle, and I also think the earthquakes, people are able to claim something, right?
Yeah, but the question is whether it's not what the event is, but it's what the event did to the obligations under this contract. So a cyclone or an earthquake will frustrate some contracts and not others. It just depends on what impact it has on these particular parties and on their obligations. So it's a really key point to remember, and it's a good one to keep in mind. Don't get fixated on the amazing, huge impact generally of a particular event. That's not the question. A big event might leave the obligations of this contract alone. A very small event, objectively speaking, might completely destroy the obligations of a party. It just depends on that interaction of what the parties agreed to and their obligations and the event in question. So that's why you can't and you should not say, for example, well, in this case, the contract was impacted by a fire. In Taylor and Caldwell, there was a fire and it was held to be frustrated, therefore this contract is frustrated. That's not what you're looking for. You're not looking for whether or not the event is the same. You're looking at whether the event has impacted on the party's obligations in such a way that performance would now be radically different. And it might not. I was going to say something about the slipping itself. The question of, and this is the point raised here, is how else was Maturin meant to fulfill its obligations? Be careful asking that question because, in a sense, that's not what we're asking. Because if they were really concerned about this risk, if they foresaw the risk and didn't say anything, then it doesn't matter that it was physically impossible to perform, because they could have written into the contract, I am not liable to fill up your fuel supply if the pipe is damaged, for example. So just because it's physically impossible by itself doesn't mean it's frustrated. It has to be physically possible in a way that the parties did not foresee about it, did not allocate the risk of it being impossible and continued anyway. So it's necessary that it's impossible, but by itself it's not a full answer. Yeah?
Do you think it's quite relevant that the parties were clearly both quite sophisticated?
Yeah, what is...
Like some standard consumer contract, as
Therefore, it is relevant, but therefore why? Why is it relevant?
Because if they're both sophisticated, they can contract out the loss.
Yeah, so the ability for them to contract out of foreseeable risks is heightened. Yes, I think that's relevant. Yeah, absolutely. Ladies in the middle, got something to add? No? Okay.
Is it maybe the frustration on Matron's side that it's quite clear that the way that they'll be fueling the air tanks is through the pipeline, and you explicitly says the pipeline.
Yep.
And it's such if anything was to happen to the pipeline, it's quite clear that they won't be able to perform their obligations.
Yep.
And that's just sort of like a necessary, like understanding from a sophisticated party. And that, something's going to happen to the pipeline, Matron obviously will not be able
To perform.
and it will therefore be frustrated because how else could it be? We only guarantee via the pipeline.
Right. And therefore, yeah, and I mean, that's right. And then the counterclaim to that would be yes, and therefore you should have known that you were staking everything on the pipeline, so you should contract out of it. But yes, no, I think that's right. That is a good argument.
Or would you then argue I can't make a pipeline out of, I can make it
Yeah.
sort of I don't know, immune to everything. It's
Yeah.
just a pipeline.
Yeah. Yeah, that's right. I think, it would be very relevant to come back and say about foreseeability of risk to that pipeline, because if you knew that there was a risk to it and you were staking everything on it, then you should try and contract out of your risk in those circumstances if something happens to it. But yeah, you're right. Like you're saying that the parties contemplated that performance would be via pipeline. It can't be via pipeline anymore. Yeah. Yeah. Cool. Okay. The point is that there are good arguments on both sides. People did very well arguing that the contract was frustrated or not frustrated. A whole bunch of people then went and talked about what the remedies are for frustration. They got 0 marks for that because that's not what we asked. 4, they didn't lose marks obviously, but they just spent time doing that. They could have done something else. The very question was whether there's a breach of the contract, and whether there's a breach will depend on whether or not the contract was frustrated. There were good arguments on both sides. The very best answers presented both sides, and then came down on one side or the other. Good? Yeah.
Like how would
And then
you
you.
come down on the argument? Like I said, if I did for and against,
Yes.
would you say, in my opinion, the best argument would be
I think the strongest argument is this. Yes. Yeah. That you can see that it's not a slam dunk case, Aubrey. But I think actually you could probably argue that it's breach, but be aware that Maturin has a reasonable argument to say it's frustrated. Yeah, that's fantastic. Exactly what you want. Yes, Lucy, and then we'll move on.
Could you please rehash your advice for me? So we can't be like, disaster A was done like this, or disaster B should be treated like this, not like that. So instead it should be...
Whether the performance of the contract in these circumstances is radically different, irrespective of how big or small objectively the disaster is. That's the point I'm trying to make. Cool. Okay. Any final questions at all? I'd recommend going and attempting to write an answer to this in the exam conditions of 45 minutes. But can you see how, all we did there was summarise arguments and read it. You still have to go and write it. So you don't have a lot of time. That's the point to get to with that exercise. So I recommend going and having a look at it if possible and writing it out when you get a chance. Okay, what we're going to finish up with today and then on Wednesday is looking at what are the consequences of a finding that the contract has been frustrated. So generally what will happen in a frustration case is one party, like we saw in Aubrey and Maturin, will say, hey, you failed to perform, and the other party will say, yes, but the reason I did so was because of this intervening event. I have a defence, and that defence is frustration. Let's then look at what the consequences are of successfully arguing frustration. So we've looked at when the contract will be frustrated, but we're now going to look at the effect of a finding of frustration, both in the common law and under New Zealand statutory regime, the Contract and Commercial Law Act. The reason that this is relevant is because the common law had one answer which was internally consistent and logical and made sense, but often was felt to lead to results that people weren't happy with, unsatisfactory results. And so the statute law was designed to ameliorate some of the harshness of the common law. But you need to know what that common law is before you can look at the statute. So, what is the impact of a finding that that the contract has been frustrated? The key point you have to keep in mind is that a contract that was frustrated due to an intervening event did not come to an, or was not void ab initio. That is, it was not as if there was never any contract at all. Instead, the contract only comes to an end from the date of the frustrating event, which means that all obligations and performance prior to the frustrating event still must be performed, and only those obligations arising after the date of frustration are excused, which is very similar to the rule relating to obligations when the contract has been cancelled. So the point is that the contract does exist up until the date of frustration, and it is only after the date of frustration that it is no longer in effect. The other point is that it's void from the date of frustration. It is not voidable. What do we mean by that? What does it mean to say the contract's void, not voidable? It is. That's why we need to get it clear.
It just is.
Exactly. It just is brought to an end by an operation of law. It is not up to the election or the choice or the decision of either party. Unlike cancellation, where it is based on the election of one party. A contract comes to an end at the date of frustration by order of the courts. It is void from that date, not voidable. But again, it's not void ab initio, that is from the start. It is only void from the date of frustration onwards. So, what effect does this have? This treating of contracts as only being void from the date of frustration onwards? Well, generally it means everything prior to the date of frustration must be performed, nothing after the date of frustration must be performed. Okay, so the contract comes into existence, must be performed up to the date of frustration, anything after that is no longer has to be performed. Which raises questions or issues when you have either performance before payment or payment before performance. Yes, Lucy?
Please say again what you mean by void but not voidable.
Void but not voidable. The courts say whether the contract is finished, void, not the parties. The parties cannot choose to continue on with the contract. It is not up to them. It is up to the courts to say it's void. It's not at the election of either party. Unlike cancellation, which it is voidable because even if the other party has made a breach of an essential term, you can still choose to continue on with performance. You cannot choose to continue on with a contract if it is found to be frustrated. Which makes for interesting results in some cases, which we won't get into. Okay, Appleby and Myers. What you had in this case was an entire agreement. What I mean by that is that one party under the construction of this contract was obliged to do everything in their entire performance, and only after they had performed in their entirety would they get paid for it. So in this case, the plaintiff was obliged under the contract to build machinery in the defendant's factory and keep that machinery in good repair for a period of 2 years. And if they did that, they would get paid for their work, but not before. You can see what's going to happen. The defendant was going to get paid at the end of 2 years, only if the machinery was built and kept in good repair during that time. And then there's a fire in the factory, and it destroys the machinery, it practically destroys the factory during that 2-year period. And the plaintiff sought some monetary award, some compensation for the work that they had done before the fire broke out. And the court said, okay, well, let's figure this out. What was it that you agreed to do, and what was it that the defendant agreed to pay, and when? So it's a very basic starting point, but it's always a good one to do. What is it that the parties have actually agreed to perform? So remember, that's what the first thing I looked at when we looked at that Albury-Maturin example. What is it that the party in breach agreed to do? And in this case, it doesn't look good for the plaintiff. Firstly, the defendant was not under an obligation, or at least an absolute obligation, to prevent fire in his premises. So the fact that the fire broke out was not a breach of contract by the defendant. Obviously, they'd be in breach if they deliberately lit the fire, potentially if they negligently allowed the fire to develop. But if it was just an accident, that was no breach by the defendant. And instead, the court said the fire frustrated the contract. It was an outside event which made performance under the new circumstances radically different. The parties contemplated having a factory for that machinery to be kept in good repair in. So the fire destroyed the factory, frustrated the contract. What does that do? Well, that excuses both sides from further performance from the date of the fire. Which means that neither side can sue the other for any obligations that they did not do after the date of the fire. So that's great for the plaintiff. The plaintiff is not liable for failing to keep the machinery in good repair for 2 years because that obligation was done away with. Not so good for the plaintiff means that he cannot sue the defendant for the money owing under the contract. Why? Because the money was only owing at the end of the contractual term. The plaintiff was not due to be paid until the work was completed. The work was not completed, and therefore the plaintiff cannot get anything. The obligation to pay would only occur at the end of 2 years. That obligation will never arise because the contract was frustrated. And that's why you don't do contracts like this as a builder. You ensure that there are progress payments, perhaps a deposit up front, monthly payments, so that you are not placing the risk of not getting paid because something like this happens. But that's not the only risk that could have happened. I mean, the factory could have gone out of business, the defendant could have become bankrupt, etc., etc. So unfortunately, the plaintiff was left with nothing, despite building the machinery and keeping it in good repair for at least some of the 2-year period. They refer to a case in this judgment, Appleby and Myers, they refer to a case that we used to study but we don't anymore, called Cutter and Powell, which was analogous in this way, that the contract was between a ship owner in that case and a sailor. The sailor promised to work the ship back to the UK, and if he did so, he would get paid quite a large rate, like a larger rate than just normal wages. Unfortunately, halfway back from the Caribbean to London, he got sick and died. His wife claimed wages for the period he was a sailor, a live sailor on board the ship before he died, and the court said, no, you can't get anything because the contract entered into was that he would perform his obligations to get the ship back to London and then get paid. Did he bring the ship back to London? No, he didn't, so therefore he doesn't get paid anything. It's an entire obligations or an entire agreement situation, just like in Appleby and Myers. And if it's frustrated, that leaves the person who is partly performed out of pocket because they don't get anything. Everyone happy? Make sense? Okay. What happens, though, if you have the reverse situation? What happens if you have payment before performance? This is another coronation case, Edward VII being crowned back in 1903, 2. And again, this was a case like Crell and Henry, where the plaintiff hired rooms to view the procession over the procession route in Pall Mall, and the contract was frustrated because the king was sick and the procession was postponed. Under the contract, though, the hirer of the room had to pay up front. You want these rooms, you have to pay £141.15 up front. And at the date that the contract was frustrated, the date that the king got sick and the procession was postponed, he had paid £100, but he still owed £41.15. And then the contract's frustrated. The hirer sought to get his £100 back, and the owner of the rooms sought to get paid an extra £41.15. Which seems a bit cheeky, but anyway. The court said, as we've seen many times, both sides are excused from further performance of the contract from the date of frustration. So look at what obligations were due and owing prior to the date of frustration, and those are still in force and enforceable. And unfortunately for the hirer of the room, he had to pay £141.15 prior to the date that the contract was frustrated. He still had to pay the entire amount owing. Why? Because the payment was not conditional upon the procession taking place. It was not conditional upon the rooms actually being used. It was a payment that was due as soon as the contract was entered into. And it was due and owing at the time of the frustrating event, and therefore he has to pay. And in return, what does he get? Nothing. So if he turned up on the day of the procession, or the original day they were going to hire the rooms, and said, look, I don't care, there's not going to be a procession, I still want to use these rooms, the owner of the room could say, tell your story walking, don't care. There was no obligation on the owner of the room to let this man who's paid £141.15 to use the rooms. Why is that? Why is that?
His obligations after the frustrating event are to this.
Yeah. The only reason the hirer has any right to enter those rooms is because he has a contractual right to do so. But that contractual right disappeared as soon as the contract was frustrated. So the result of this case is that the hirer must pay £141.15, and in return he gets nothing. But that's the risk he took. He agreed to pay up front. That's the argument that the courts would say, well, you agreed to pay up front, something might have happened, something did happen, sorry, you have to pay. Yes, Lucy?
Why did the owner of the rooms want the extra £41?
Because he wants 41, because he wants the money. Like, yeah, it would have been nice to say, oh, don't worry about it, but no, he wants the money. You owe me £141, pay me. And the court said, yes, very clearly, they did owe £141, and that means they don't get the £100 back, and also they have to pay this extra £41.15, because why should you be in a better position just because you haven't done what you were meant to have done, which was pay that money? Yes?
I'm a bit confused by the logic, because for that price you'd at least be able to use the room, right? But then on the day he wasn't even allowed to use the room, so
he's not allowed to use the room because he has no contractual right to use the room.
But didn't he pay for use of that room on that day?
He did. Why does he not have a contractual right? Because the contract has become frustrated. There is no contractual right anymore because the contract has ceased to exist from the date of frustration only. So he turns up on the day he hired the rooms, and the other party says, you have no contractual right to use these rooms.
Was it because the king got sick?
And the procession was cancelled, yes. It was frustrated. And therefore, the contract ceases to bind the parties going forward. But you still have to do what you were meant to do prior to the date of frustration. That all makes logical sense, I think, and is justifiable as a matter of logical progression. But you can understand why the courts were a little bit uneasy with this result. You essentially have someone getting £141.15 for nothing. And so that's why this case was was overturned by the House of Lords. So Chandler and Webster was a UK Court of Appeal decision, and 40 years later, beg your pardon, the House of Lords had a chance to revisit this, and they did in the case of fibrosis Spolka. So in this case, you had exactly the same situation where you had payment being made prior to performance, after the date of payment, but before the date of performance, you had a frustrating event. And in this case, it wasn't that the king got sick, but that war broke out between Germany and Poland, and eventually between Germany and the UK. The parties had entered into a contract whereby the maker of goods, or a seller of goods, would supply goods via ship to Gdansk in Poland. They entered into this contract in, I think, July. They were paid a deposit, but prior to the goods being shipped, you had Germany invade Poland on the 1st of September, and then war breaking out between the UK and Germany. So when it came time for the goods to be shipped to Gdansk, Gdansk was no longer part of Poland, it was part of Nazi-occupied Poland, probably Greater Germany at the time. So sending goods there would have been, A, very dangerous, but even if you could get them there, you would have been delivering them up to Nazi-occupied Poland, which means that you would have been supplying the enemy, which means you would have been guilty of treason. It was illegal to supply goods to Nazi-occupied Gdansk. So the contract was frustrated due to the outbreak of war. The question was, what happens to that deposit that was already paid? So you've got goods that haven't been delivered, but there's been some money paid, in this case the deposit. So the question is, could the advance payment be retrieved? And applying Chandler and Webster, the case we just looked at, the answer should be no. Because the advance payment was made when the contract existed, no further obligations need to be made after the outbreak of war, so you don't need to deliver the goods, but that payment still should be paid and was paid and doesn't need to be returned. The court, however, said, we don't like Chandler and Webster. We're the House of Lords, we're not bound by the Court of Appeal. And so what we say is that when one party has made payment to the other, and in return there has been a total failure of consideration, then that payment can be returned. What they mean by this is that the party who has paid money has received no performance in return. And the court says you have to be a bit careful. What we're talking about in total failure of consideration, we're not using consideration in the sense that it's used for contract formation. Because if there has been a binding a binding contract, there will never have been a total failure of consideration, because obviously if there's no consideration, there's no contract. And the reason there was consideration at the time they entered into the contract was both parties promised to do something. I promised to pay you, you promised to deliver the goods. So obviously there's been consideration in the sense of a promise. But what we're talking about is whether that promise has eventuated into any performance to the other party. Have they given something in return for that money? And if not, if they've given nothing, then that money will be returned. Yes?
Did they say how much performance could be given? 'Cause
none.
so if you did the tiniest bit of performance, this rule would fail.
Correct. There is a question, maybe substantial lack of performance, but generally no, total failure of performance. So it would deal with situations like Chandler and Webster. It would deal with situations like Fibrosa-Spolka. It would not deal with situations where there has been some performance. And the reason for that is because the courts have no way of allocating price really to that performance, and they can't do some sort of restitutionary balancing exercise. And this is exactly what the courts say in Fibrosa-Spolka. They say this will help in these situations and will obviate situations like Chandler and Webster. It will make the law less harsh, but it doesn't help in all cases. It doesn't help where there has been some performance. It doesn't help what happens if someone gets an advanced payment, uses that money to buy the goods in question from a third party to supply on. According to Fibrosa-Spolka, you still have to return that advance payment even though you're out of pocket by performing the contract, by buying the goods from someone else. And so that's why the House of Lords says, actually, this is not an absolute help. It doesn't solve every single situation. We can't solve it with the tools we have available. We need Parliament to pass a law to do some sort of restitutionary balancing exercise, or to give us the power to do a restitutionary balancing exercise in these other cases, where some performance but not all performance has been done, where they have spent money in trying to perform the contract to a third party. And amazingly, this case was decided in the middle of 1942. Amazingly, you'd think UK Parliament had better things to do than reform the law relating to frustration. Within a year, Parliament had passed the Frustrated Contracts Act to try and solve some of these issues that were identified by the House of Lords and Fibrosa Spolka. You'd think 1942, 1943, the UK Parliament had better things to do than that. There were some other pressing issues that might need to be addressed with, like a world war. But no, they had their priorities right, and frustration comes first. And so they passed this law. It's a very short law. And we in New Zealand, because we used to do things right back then, stole it and crossed out the word UK and put in the word New Zealand, and exactly the same wording was used in our Frustrated Contracts Act of 1944. And that law has been subsumed by the Contract and Commercial Law Act, sections 60 to 69. So those sections go all the way back to the UK Frustrated Contracts Act of 1943. It's substantially the same law. And it's to try and deal with these situations where performance from one side or the other has occurred prior to the date of frustration. We're going to look at that on Wednesday. But what you need to realise as you're reading these sections, and they're not many, it's about 4 pages of the Contract and Commercial Law Act, it's not much. Read those sections. Figure out, would these help in situations like Appleby and Meyer, the factory owner, the machinery owner where the factory burns down? Would it help in cases like Chandler and Webster or Fibrosa Spolka? And also consider that no legislative amendment or help is going to be perfect. Because unfortunately, in most of these cases where you have frustration, one or both parties is going to lose out. And it's just trying to figure out, is there any way we can lessen those losses for one or both parties in a situation where the contract has come to an end through neither party's fault? And so the case I want you to read for Wednesday is Gamerco, which is all about Guns N' Roses and a frustrated contract to put on a show in Madrid, or Barcelona, Madrid, Spain somewhere, and how the courts use the UK's Frustrated Contracts Act to try and allocate the losses between the parties. And even though it's the UK's Frustrated Contracts Act, it's still relevant because that law is substantially the same as in New Zealand. Okay, last question, then we'll go. Yeah, Lucy.
So did Fibrosa Spolka overturn Chandler and Webster?
Correct, yes. Yep, so Chandler and Webster was no longer good law after Fibrosa Spolka. They were both overtaken by the passing of legislation the next year.
What does it mean to obviate?
Obviate means to lessen, ameliorate. It's a good word, obviate. Any other questions? Okay, I'm going to let you out a bit early because I didn't give you a big enough break at the start. We'll see you on Wednesday, and we'll finish frustration on Wednesday. Have a good couple of days. See you guys. Obviate.
You know when you talk about overturned cases,
Yes.
So when you said make that cheat sheet, right? Is it like reliable to put those on our cheat sheet, or do we just put the leading House of Lords case? You said they're like problem questions, right? So I'm not going to be thinking I could use it for like understanding, but I'm not going to be using some.
No, probably not. Yes, that's right. Unless there was some issue about whether New Zealand would follow that House of Lords decision. That would be the only reason you'd want to have the decision. Yeah, no problem.
Sorry. Hi. I just have a question for that. When you said about the advanced payment, yes. Like, what is that?
Oh, so I'm delivering goods. So you enter into a contract whereby you will pay me and I'll give you goods.
Mm-hmm. Yeah.
What happens if I don't have the goods? What happens if I need to make the goods? And so you pay me in advance, I use that money to go and build a factory to manufacture the goods.
Yeah.
Contract's frustrating. According to Fibrosis Volca, because I haven't given you anything, I have to give that money back. So now I'm out of pocket because I got this factory that's useless, or I bought these goods that are useless, or I've trained someone to do something that's useless.
Okay.
So that's what he's talking about, and he's saying that we can't do anything about that, so we need legislative intervention. And that situation that I just described is one of the situations that the Parliament is trying to deal with in the legislation.
Okay. So basically there was kind of like a subcontract to a third party.
Potentially.
Yeah.
So so I'm not saying that happened in Fibrosis Volca.
Okay.
What the House of Lords said was, that's a situation that we can't deal with. I'm not saying it is the situation.
Yeah, in that case.
In that case, but we need law change to deal with that situation.
Okay. Got it. I was just confused.
No problem. Good question. Right, we're going
I'll walk you up to the door and then I can keep my ear and then I can make my face hang out.